petitioners in petition number 234 of 2023. In summary, my lords, my lady, the petitioners rely on the amended petition dated 10th August 2023 and the supporting affidavit of Dr. Charles Wire the same day, as well as the written submissions and the list and bundle of authorities, all dated 5th September 2023. In the interest of time, I adopt the averment in the petition, the depositions in the affidavit, and the contents of the submissions, in which highlight the following brief aspects. Number one, this petition brings on board the voice of the workers in this dispute. If the Finance Act 2023 shall go down in history as an oppressive piece of legislation to the Kenyan public, then the most oppressed, the core of the oppressed in that statute shall be the workers of this country, as I will demonstrate shortly. There are two aspects that these petitioners focus on in their challenge of this legislation, and that is number one, that part of the Finance Act, that is Section 26, that amended the Income Tax Act to increase certain individual income taxes, and number two, Section 84 of that Act, which amended the Employment Act at Section 31B, so by introducing Section 31B. Allow me, my lords and my lady, to begin by laying the constitutional basis of this challenge. I'll start with Article 19, Clause 3B of the Constitution, which provides that the rights and fundamental freedoms in the Bill of Rights do not exclude other rights and fundamental freedoms not in the Bill of Rights, but recognized or conferred by law, except to the extent that they are inconsistent with this chapter. Then clause paragraph C, which provides that those rights and fundamental freedoms are subject only to the limitations contemplated in this Constitution. It follows, therefore, that the rights of workers that are provided for in, among other statutes, the Employment Act, form an integral part of the Bill of Rights by instrument of Article 19, Clause 3, Paragraph B of the Constitution. And therefore, if one wants to limit the rights of workers as set out in the Employment Act, they must comply with the criteria for limitation that is spelled out in Article 24 of the Constitution. And this is what then Parliament does in enacting Section 84 of the Finance Act. It amends the Employment Act by inserting Section 31B, which provides that notwithstanding the provisions of Section 32A, B, C, and D of the Act, this is a very egregious part of this statute, because this is what the statute does. Section 32A, B, C, and D of the Employment Act removes certain persons from the application of the Employment Act. It says if you people employed under the Armed Forces Act, under the Prison Service Act, and the National Police Service Act, and that Act, the Employment Act, does not apply to them. What Parliament does in the Finance Act is to bring them back to the Employment Act for the limited purpose of taxing them. It says we shall bring it, notwithstanding Section 32A, we shall bring you back for the limited purpose of levying the housing levy on you. Then disapply the rest of the provisions of that act in terms of the other rights of employees to you. It's the only statute I know, my lord, that imposes only obligations on a subject and expressly denies them corresponding rights under the same law. That is the Finance Act that is being litigated before you today. But in the interest of time, what is the net effect of these two provisions that we have singled out? The Trade Unions Congress appeared before Parliament and has come before you and said, look, there is section 19 of the Employment Act that ring-fences, that protects wages and incomes of employees from unregulated deductions. All of them, including statutory deductions like taxes. And it says, okay, we are going to allow the following categories of deductions. But says, whatever you do as the deducting agency, the employer, if you may, do not effect deductions on the salaries of an employee so as to leave an employee with anything less than 1/3 of his income. So the Trade Unions Congress goes before Parliament and says, look, if you wantonly introduce new taxes targeting employees, as you have done in Section 36, increase the Income Tax Act for certain bands of employees, and through an introduction of Section 31B of the Employment Act, introduce a new tax, the housing levy. What you do is that you are adding them to the existing deductions, and the employer has no choice over these ones. Address yourself to that question. Apply your mind to it, that what is the effect of these consequential amendments to the protections under Section 19 of the Employment Act. My learned colleague Ochel Dudley summarized for you what the Parliament said. It said that invitation is rejected. Why? Are you saying that it's nonsensical? It makes no sense completely. Are you saying that when stakeholders tell you that apply your mind Section 19 of the Employment Act, they are being irrelevant in the considerations that they are inviting you to apply? Is that kind of arbitrariness where an invitation of this nature is rejected by a wave of the hand with no reasons supplied, that then a debilitating blow on the constitutionality of these provisions of the Finance Act? They render provisions on public participation illusory. They have no effect. My clients at least expect reasons on why these invitations take into account the provisions of Section 19 of the Employment Act were not taken on board. But more importantly, when we bring the matter before this court, what do the respondents tell this court in their reply? They say no. The duty to ensure Section 19 is complied with is not that of we the lawmakers. That's in complete violation of Articles 20 and 21 of the Constitution that make it the obligation of every person to ensure respect for rights and freedoms. So it's not the obligation. It is the obligation of the employer. And two, it is for the employees, that's what they are saying in their responses before you, to go and negotiate with the other lenders, the people they owe the Shylocks, to rearrange their deductions so that they remain within that minimum 30% rule. It is not the obligation of Parliament to take that into account. I submit respectfully that the state's obligations to protect its citizens was highly compromised by that attitude on the part of the lawmaker as they made this law, and on their part as they responded to the decision before this court. Allow me to also address the impact of Article 24, Clause 2A of the Constitution on the matters before you. Article 24, Clause 2, Paragraph A, provides that despite Clause 1, that is the clause on how rights can be limited, a provision in legislation limiting a right or fundamental freedom In the case of a provision enacted or amended on or after the effective date, as is the case of the Finance Act here, is not valid, that's what I'm emphasizing, unless the legislation specifically expresses the intention to limit that right of fundamental freedom and the nature and the extent of that limitation. We submit that an employee has proprietary interest in his income. An employee's income is an employee's property, duly acquired after laboring for the period of labor for which he is paying. For the lawmaker to enact provisions in the nature of Section 26 of the Finance Act and Section 84 to take away a part of that property, by law, compliance must be had to Article 24, Clause 2, Paragraph A of the Constitution. We invite you to look at that law, and you will realize that in terms of the bill, the proposal to enact that law in the nature of the bill, it lacked that specificity in terms of specifying that it intended to limit employees' property rights within the meaning of Article 40 of the Constitution. And what the Constitution says is that if that happens, then that legislation is not valid. If I get this background, that the petitioners in petition number A234 invite you to declare that sections 26 and 84 of the Finance Act are invalid and of no effect, and to strike them out accordingly. In addition to all that, I invite my lords to look at our written submissions that explain those points in detail, and the rest of our submissions at that juncture. Thank you so much.
We now go to